Cool. Okay, we are now live on YouTube. All right. Let me bring in the participants. Admit all. Okay. Okay. Gotta get going here. Good afternoon, everyone. Welcome back to County Court 9. This is our plea docket. We're going to get ourselves, get our pleas done, and then I have a motion to dismiss for lack of speedy trial. So, let me start with, let's see, I'm just going to see, Eduardo Rene Rodriguez. Do we have a plea for Mr. Rodriguez? Oh, no, that's Mr. Ramos's client. Okay. Mr. Garcia, who is yours? That's Mr. Ruiz?
Yes, Your Honor, Arturo Ruiz.
Okay. Is he in your office or is, oh, I see him. Mr. Ruiz, will you please unmute yourself, sir? And then turn on your video, please. Okay, that's Mr. Van Pelt.
Yes, ma'am.
Mr. Ruiz, turn on your video, sir, please.
Your Honor, I don't think he's got audio.
Oh, he doesn't? Okay, well then, I guess we'll have to come back. Will you go in a breakout room with your client, Mr. Garcia?
Let me, sure, Judge.
Okay. I'll later
Hoping
pick them in a breakout room. All right, so then I've got Michael Wayne Van Pelt. And are you ready to proceed on this?
Yes, Judge.
All right. So, Mr. Van Pelt, I'm going to ask you to take your hat off, sir, please. Will you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God?
Yes, I do, Your Honor.
Thank you, sir. You may lower your hand. This is cause number 667674, the state of Texas versus Michael Wayne Van Pelt. Counselors, please make your announcements.
Jeff King on behalf of the state.
James Hunt for defense, ready.
So are you Michael Wayne Van Pelt?
Yes, ma'am.
Are you a U.S. citizen, sir?
Yes, ma'am.
I'm sorry, I didn't hear that answer.
Yes, ma'am.
Okay, our audio is skipping today. Sometimes we hear just every other word. Okay, so as you, we will see in a moment a document entitled Defendant's Waiver of Constitutional Rights. There we go. And so, Mr. Van Pelt, you are charged with the offense of driving while intoxicated as a first. Mr. King, is that how the information was originally presented?
No, Your Honor, we are waiving the enhancement.
Any objection?
No, Your Honor.
I'm sorry, I didn't hear that.
I'm sorry. No, Your Honor.
All right, thank you. All right, so as you see, you are charged with the offense of driving while intoxicated as a first offense as a Class B misdemeanor. And the range of punishment for that is from a minimum of 72 hours up to a maximum of 180 days in Bexar County Jail and or a fine of up to $2,000. You see that, Mr. Van Pelt, right?
Yes, ma'am.
So we're going to go to page 2 where it says defendant signature. I want you to tell me if you signed that.
Yes, ma'am.
All right. Do you understand that by signing that document, you are waiving your right to a jury trial, your right to remain silent, as well as all those other rights listed in that document?
Yes, ma'am.
if you have an agreement with the state and I follow it, but then later on tonight or tomorrow, you have a change of heart, you want to take back your plea, you would need my permission to be able to do that. But I do not have to give that permission. Do you understand that, sir?
Yes, ma'am.
If I assess a harsher punishment than what you have agreed to, you can take back your plea and nothing you've said or signed for today's hearing can be used against you. Also, if you enter a plea of no contest to this charge, I can still find you guilty of this charge. Do you understand that, sir?
Yes, ma'am.
All right. So, Mr. Hunt, have you had an opportunity to discuss the charge with Mr. Van Pelt?
I have, Your Honor. I have, Your Honor.
All right. In your opinion, does he have a factual as well as a rational understanding of the charge?
Yes, Your Honor.
Has he in his defense?
You're garbled, but yeah, I believe that he's competent and he understands everything that is presented to him.
Okay. And he has been able to assist you in his defense?
Yes, Your Honor.
Thank you. All right. So I approve the waiver. Is there an agreement?
Yes, Your Honor. We have agreed to 180 days in Bexar County Jail, probated for the term of 14 months, a $500 fine, court cost, DWI intervention, the victim impact panel, a TAP evaluation, ignition interlock for 1/2 the term, $60 restitution and reimbursement to Texas Department of Public Safety, a driver safety course, 60 hours, that's 60 hours of community service, restitution, if any, to Miss Rita Godina. TIC case number 667-673, and that dismissal will be coming to you here shortly, Your Honor.
All right. The only thing I didn't get was you took into consideration cause number
667-673.
I think I'm missing one number, 67673.
No, 67673.
Great, thank you, got it. So, Mr. Hunt, is that your understanding of the agreement?
That's our full agreement, Your Honor.
Okay, so Mr. Van Pelt, to the offense of driving while intoxicated as a first offense, how do you plead, sir?
Guilty. Mr.
Well,
Van Pelt would like to confirm with the plea bargain and enter a no contest plea.
Oh, yes.
No contest. Okay, that's what it is on your document, so I'm going to follow that. Is anybody forcing you to enter this plea?
No, ma'am.
Are you doing this of your own free will?
Yes.
I accept your plea. I am going to assess a $500 fine plus court costs, sentence you to 180 days Bexar County Jail. However, that is probated for 14 months. You are to complete the DWI intervention course, the victim impact panel, a TAP evaluation, install on your vehicle ignition interlock for 1/2 term of your probation, pay $60 restitution to the Department of Public Safety, take a driver safety course, complete 60 hours of community service, and pay restitution, if any, to Ms. Rita Godina. And as part of this agreement, taken into consideration, cause number 667673. I'm going to offer you one more thing, Mr. Van Pelt.
Yes.
And that is, I will offer you 30 hours credit against your community service requirement if you are or become fully vaccinated for COVID. That's purely optional. It's only help to you. I think it is, my opinion, is a form of public service. But if you have already been vaccinated, then you just need to show that proof to the probation department and you will get that credit. Or if you become fully vaccinated, show the proof to the probation and you'll get that credit. Okay?
Yes, ma'am.
All right.
Yes, ma'am.
Is there anything further from defense?
No, Your Honor. Thank you.
Anything further from defense?
No, Your Honor. Thank you.
No.
And anything further from the state?
No, Your Honor.
Anything further from the state? No. Okay.
No, Your Honor.
So, Mr. Van Pelt, I have followed your agreement, sir. That means you do not have a right to appeal. You did fill out a personal data sheet. Do you swear that everything on that data sheet is true and correct to the best of your knowledge?
Yes, ma'am, I do.
All right. Thank you, sir. I'm going to terminate this hearing. Our audio is very difficult today. I'm going to ask you to go to a breakout room and meet with Mr. Richardson. He's going to give you important information on what to expect and how to proceed. Okay? I want to wish you the best of luck, sir. And you will get on your screen a prompt that says join breakout room, whatever. You click on that, and then after you finish, you can leave from there. Thank you. Okay.
Thank you.
Thank you, Mr. Hunt.
All right.
You have a good
Thank
afternoon.
you, Your Honor. Thank you, Mr. King. If that went
Okay.
through.
All right. So at this time, Mr. Garcia is back.
Yes, Your Honor. I'm sorry. He's ready.
Okay. Mr. Ruiz, will you please unmute yourself, sir?
Yes, ma'am.
All right. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God?
I do.
Lower your hand. I'm going to talk slowly because our audio is failing us. So we might be able to understand every other word. Okay.
Yes, ma'am.
At this time, I'm going to call the number is 677-405, the state of Texas versus Arturo Ruiz. Counselors, please make your announcements.
Karina Sanchez for the state.
And Judge Richard Garcia for the defense. Ready?
All right. So are you Arturo Ruiz?
Yes, ma'am.
Are you a U.S. citizen, sir?
Yes, ma'am.
Okay. I think I'm going to have to ask you to repeat that because our record did not hear you.
Yes, I am a U.S. citizen.
Thank you, sir. All right. So we're going to put a document on the screen entitled Defendant's Waiver of Constitutional Rights. As you see, you are charged with the offense of criminal trespass on private property. And that is a Class B misdemeanor. If you could scroll up just a little bit, Alita, please. The range of punishment for that is up to 180 days in Bexar County Jail and or a fine up to $2,000. See that, Mr. Ruiz?
Yes, ma'am, I do.
Okay. You reviewed this document with your attorney, correct?
Yes, ma'am.
So we're going to go to page 2 where it shows defendant's signature. And I want to ask you if you signed that document. Is that your signature?
I don't see it, but I did. Oh, yeah, there it is. There it is. Yes, ma'am, I did.
All right. Do you understand that by signing that document, you are waiving your right to a jury trial, your right to remain silent, as well as all those other rights listed in that document?
Yes, ma'am, I do.
If you have an agreement with the state and I follow it, but then later tonight or tomorrow, you change your mind, you want to take back your plea, In order for you to do that, you would need my permission, but I do not have to give that permission. Do you understand that, sir?
Yes, ma'am, I do.
If I assess a harsher punishment than what you have agreed to, then you can take back your plea, and nothing you said or signed for today's hearing can be used against you. Also, if you enter a plea of no contest to this offense, I can still find you guilty of this offense. Do you understand that, sir?
Yes, ma'am.
Mr. Garcia, have you had an opportunity to discuss the charge with Mr. Ruiz?
Hello?
Mr. Garcia, have you had an opportunity to discuss the charge with Mr. Ruiz?
No questions.
Okay. Have you discussed the charge with Mr. Ruiz? Have you discussed the charge with Mr. Ruiz?
Yes, Your Honor, I have.
Does, in your opinion, does he have a factual as well as a rational understanding of the charge?
I believe he does, Judge.
Has he been able to assist you in his defense?
Yes, he has, Judge.
I approve the waiver. Is there an agreement?
Yes, Judge, that agreement is a $0 fine with court costs, 1 day in the Bexar County Jail, credit for time served, time and money to run concurrently, and if it pleases the court, this would satisfy the judgment.
Mr. Garcia, is that your understanding of the agreement?
Yes, it is, Your Honor.
Is that your understanding of the agreement?
Yes, Judge, it is.
Thank you. So, Mr. Ruiz, to the offense of criminal trespass on private property as a Class B misdemeanor, how do you plead, sir?
I plead no contest.
Is anybody forcing you to enter this plea?
No, ma'am.
Are you doing this of your own free will?
Yes, ma'am, I am.
I accept your plea. I'm going to assess a $0 fine plus court costs. Sentence you to 1 day Bexar County Jail. You get credit for time served, the time and money run concurrent, and the court finds your judgment is satisfied. Is there anything further from defense?
No, Your Honor. Thank you.
Anything further from the state?
No, Your Honor, thank you.
So, Mr. Ruiz, I have followed your agreement, so that means you do not have a right to appeal. I want to wish you the best of luck, sir. This hearing is adjourned. Thank you very much.
Thank you,
Thank
Judge. Appreciate it.
Okay, now we are going to move on to the motion that Mr. Ramos has brought. Ms. Sanchez, are you going to do that?
No, Judge, I'm going to let ADA King do the second half of this.
Okay, all right. All right, so let me call it.
And Judge, we are continuing the record from the last time we were here last week.
Yes. Okay. I just need to find my docket. I've got too many papers on my desk. All right. All right, this is cause number 668444, the state of Texas versus Eduardo Ruiz. And I guess maybe that's Rene Eduardo Ruiz Rodriguez. Sorry about that. Okay. At this time, we're going to resume the hearing that we started last week on the motion to dismiss for lack of speedy trial. Counselors, please make your announcement.
Jeff King on behalf of the state.
Rick Ramos for the defense, Your Honor. We do have one preliminary matter before we begin, Judge.
All right, thank you. Yes, you may proceed.
Yes,
Mr.
Judge. At this time, Your Honor, we would like to call Mr. Rodriguez to testify. However, we'd like to ask the court's permission to limit his testimony today just for the purposes of this motion and not to go into the facts of the case, Your Honor.
Is there any problem with that, Mr. King?
Well, Your Honor, I think there are some pertinent facts that are definitely relevant, such as, I mean, this is a speedy trial. So when he was arrested is definitely relevant to his speedy trial, and any waivers that he might have done, such as asking for more time or anything else with defense counsel or with the court or whatnot, that show his own delay.
Right. So are you thinking of something other than those basic facts, Mr. Ramos?
No, Your Honor, that would be fine with us as far as the date of arrest and anything that happened after. We're talking more specifically as to the interaction with the officer.
Okay, well, I don't know. There wouldn't be any problem with not getting into the details about the interaction with the officer, would there?
I have no intention on going there, Your Honor. I mean, it's totally irrelevant to the speedy trial issue.
All right, that's fine. Okay, so we'll grant your request, Mr. Ramos. At this time, I see Mr. Van Pelt is back from the breakout room. Mr. Van Pelt, can you hear me, sir? Aleda, will you indicate to Mr. Van Pelt that he is free to go, please? All right, at this time, and Mr. Rodriguez, I need for him to unmute himself and to start his audio, video. Okay, sir, will you please raise your right hand, Mr. Rodriguez? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I'm sorry?
Yes.
Would you repeat that?
Yes, I do.
Thank you, sir. Okay. At this time, I don't remember who's going to go first. It is Mr. Ramos's burden, so I'll let you go first, Mr. Ramos, okay?
Yes, we'll. Thank you. Mr. Rodriguez, could you please introduce yourself to the judge and spell your name for the court reporter slowly, please?
Eduardo Rodriguez, and that's Eduardo, Eduardo, Rodriguez, Rodriguez.
Okay. And how old are you, Mr. Rodriguez?
I'm 29 years old.
Are you currently married or have any kids or anything like that?
No, I am not. No kids, and I am not married.
Okay. What do you do for a living, Mr. Rodriguez?
I'm a pediatric nurse.
Do you hold any sort of special licenses to be able to have that job?
Yes, I'm an LVN. I have my LVN license.
Okay. You understand why we're here today?
Yes, sir.
Okay. I want to talk to you in a very limited capacity. So without getting into any details, let's just talk a little bit about this situation we've got today. Do you remember when you were arrested, Mr. Rodriguez?
Yes, I do.
Okay. What was the date of that arrest?
August 29th, 2021.
Okay. And again, I want to talk about if you've been affected. How have you been affected? Let's not get into details, but just give the judge a kind of a quick summary if you've been affected at all by this.
This has definitely affected me, definitely in my anxiety levels, stress levels, and just at work, troubles at work.
Okay, let's kind of break that up a little bit, okay? You mentioned that you've been dealing with some anxiety and stress. What is, I guess, describe that to the judge. What's going on with those things?
I have heart palpitations and kind of like brain cramps. And I've actually had to go to the hospital sometime in November, early November, for a anxiety attack.
Okay, let's kind of break that up a little bit. You mentioned you had some brain cramps and some palpitations.
Yes, heart palpitations.
Okay, describe that to us, or why does that happen, or what's going on when those things happen?
It's sort of stress and anxiety. They pretty much go hand in hand with each other. I start getting stressed out, start getting anxiety. And it's just me worried about, this whole situation, my job, my livelihood.
What are you worried about? What's going on? What are you thinking about when these things happen?
Losing my job, definitely.
Is that something that could potentially happen if you were convicted on this case?
I think if I am convicted, I think, yes, I can probably lose my license, my nursing license.
Okay. You mentioned you had to go to the hospital in November.
Yes.
What happened with that?
I was getting heart palpitations during one of my shifts. I was actually taking care of my patient, and he had a doctor's visit at a hospital downtown. And we had to go back to his house via ambulance because I was getting an anxiety attack, and his grandfather had to drive me to the hospital.
What were you having the anxiety attack about?
It was just everything, this whole situation with my ticket. It has just been a really big part of my anxiety.
Okay, when you mentioned your ticket, are you talking about this charge that you're arrested for?
Yes, this is this charge.
Okay, and just so that we're clear, is that a DWI that we're talking about?
Yes, sir.
Okay. I want to talk a little bit now. You mentioned some trouble with work. Can you kind of describe to the judge what you do for work first before we get into how work is affected?
Yes, I am a private duty licensed vocational nurse. So I work with medically fragile patients. So patients who can't really do much for themselves, or we don't want them to go into doctor's offices due to COVID and all that, of course. So I do go to their home, and I have to travel there.
Okay. What's going on with your license since this case has happened?
My license has been suspended since, I forgot the exact date, but I want to say since I received this charge. And I've been having to get my roommate to drive me around for work.
Okay. And how has that affected you?
Well, it's just been a burden to me and to her.
Okay. I'd imagine that's added some more stress to you.
Absolutely.
Okay. So we talked a little bit about anxiety and stress levels and your troubles at work, your fear of losing your license. Is there anything else that you feel we left out that, as far as how you've been affected since you've been arrested?
For this charge, yes, that's pretty much it.
Okay. Your Honor, we passed the witness to the state.
All right.
Good afternoon, Mr. Rodriguez.
Good afternoon.
So you are a medical professional?
Yes.
And it is fair to say that anyone arrested would suffer from anxiety, correct?
Yeah, everyone suffers from anxiety differently, yes.
Right. And nobody would like being arrested.
Yeah, of course not.
Okay. Now, I noticed that you were arrested August 29th, 2021.
Yes.
And then I have that your first hearing was February 22nd, 2022.
Mm-hmm.
Right. Is that correct?
I believe so. I don't know the exact date.
Okay. Did you demand a speedy trial on February 22nd, 2022?
I believe so, yes.
Okay. And then, so you're ready for trial? So are you prepared to proceed to trial?
Yeah, I think so.
Okay. Would a jury trial stress you out?
Yeah, it would stress anybody out.
Yeah, of course. Make you worry too, right? It will make you worried? Yeah. Now, if a jury convicts you, then you're convicted. Would that affect your license?
Yeah, if I'm convicted, it would affect my license, I believe so.
You probably lose it, right?
Yeah.
Have you tried, through your attorney, of course, reaching out to the prosecutors to possibly get a plea offer or resolve this in a different fashion?
We would object to speculation, Your Honor, in regards to him asking him what I've done, Judge.
Sustained.
I'll move on. I'll move it on. Now, trials have just restarted due to COVID. So can we agree to go ahead and set you for a jury trial as soon as possible?
Isn't that what we did? Second.
We haven't set you yet. We're having a hearing over speedy trial.
This is Court Reporter.
What?
Can you restate your answer? Isn't that what?
What was that? I don't understand what's going on.
Restate your answer. Isn't that what I didn't get all of your answer. If you could restate that.
I thought we did set a date for trial for February 22nd. I thought that's what that was, the speedy trial.
That was your first hearing, Mr. Rodriguez. You were arrested, and then your first hearing, like a pre-trial, was set for February 22nd, 2022.
Okay.
Understand? Okay. Your license is temporarily suspended right now because of the accusation, correct?
Yes.
Would you lose your license if convicted?
I believe so, yes.
Is that because you didn't get a speedy trial?
I don't know. If I'm convicted, I'm pretty sure I'll lose my license.
Right, but you have a temporary suspension right now because of accusation, correct?
Yes.
Which was from less than a year ago, from August.
Yeah, from August 29th.
No further questions, Your Honor.
Okay. Mr. Thomas?
I have nothing further for Mr. Rodriguez, Your Honor.
All right. Okay, and was there anything else you would like to present?
Your Honor, just argument at this point, and we have case law as well that I can send to both the state as well as to the court. If I just wasn't sure which email to send it to, Your Honor, if I should send it directly to you or to.
You just send it to Aleda and she will forward everything to me.
Okay, and I'll have Mrs. I'll have both the state CC'd on it as well, Your Honor.
All right.
But whenever the court would like to hear argument, we're ready, Judge.
All right. Is there anything else you want to do before we hear argument, Mr. King?
No, Your Honor.
All right. Go ahead, Mr. King.
Yes, Judge. So as the court's aware, I believe when we first started this hearing, the court took judicial notice of the court's file as it's indicated on the website. I know the state today was questioning Mr. Rodriguez in regards to February 22nd being his first hearing, but that's just not true, Your Honor. We had come to court several times before that. In fact, that's how we were able to confer and talk about the discoveries that first the discovery motion that was entered, that I believe that was done in December. And if I'm not mistaken, according to my records, we were in court that day, Judge. So we came into court, had the order signed, and the reason that it was reset to February 22nd was because that was the day that it would have been 60 days for the court or for the state to comply, just a little over 60 days for the state to comply with that order, which is in fact when we discussed for the first time a speedy trial issue because the state had not complied with that order, Your Honor. So we just like the court to take notice of that. Mr. Rodriguez has come before the court. It's very embarrassing for him as a medical professional to have to, admit that these things are going on with him in regards to having anxiety attacks so bad. I mean, it's easy to say, yes, everybody suffers from anxiety. Everybody would be stressed out, Your Honor, but this is just taking it to another point, to the point where somebody's being hospitalized. Somebody's having to be taken to the hospital by a patient's parent. It's extremely embarrassing in what he's dealing with. Due to the stress of this case, Your Honor, as we talked about before, getting a trial setting, while it is the normal remedy for this type of situation, Judge, it just doesn't suffice in this case because what the state is intending to do, and I believe what they're going to argue is say, well, this is a motion for speedy trial, Judge, just give us a trial setting. But the reason why the prejudice is so big in this case, Your Honors, because the state has in fact failed to turn over evidence. So what will we foresee happening if the court were to give the normal remedy in this situation is, let's say we get our jury trial next week and the state turns over thousands of pages of blood discovery on us, even if it were a week, even if it were a month before trial, Your Honor, it wouldn't suffice. It would not be enough time for us to be able to go through everything that's going to be turned over, from all of the chromatograms to all of the licensing documents that are provided by these labs when they turn over, because they don't make it easy for us to find anything, Your Honor. They dump everything into folders, into PDFs. They hide things, in my opinion, but it's our job to sort through that, and we would need time to do it. So that's why this prejudice rises to a whole different level. And the normal remedy of just setting a jury trial is not enough, Your Honor, because to this day, the state has still not complied with the order signed by this court on December 17th, and they have not turned over any blood discovery. So the only remedy that would suffice to protect Mr. Rodriguez's constitutional right would be to find that the state has in fact denied him his speedy trial, and that if they haven't done it even to this point today, Judge, even if we were to set it on a date that the court has available for us, his constitutional right is still going to be violated. Why? Because now he's going to be forced to take a not ready when the state turns over late discovery to the defense, Your Honor, because there's no way that we would be ready if that was dumped on us, a day before or a week before, whatever the case may be. We did provide to the court in the email that was just sent to Ms. Castillo a case by the name of Ex parte Kevin Day Sheffield. And I will note for the court, as well as they will see, that there is a key site for it. It is flagged because it is currently going before the Court of Criminal Appeals of Texas. So we don't know if this will become binding on us at all or not. But the Court of Appeals in Amarillo did find, Your Honor, that COVID, and using that as an excuse in regards to the emergency orders, that even the Supreme Court, when they came out and gave those orders, did say that this was subject to constitutional limitations, and that you can't rely on that order to deny somebody's constitutional right that falls both under the U.S. Constitution as well as the Texas Constitution, the right to a speedy trial. So on those grounds, Your Honor, they did flat out say you can't rely on that. That is not a good enough reason to just say, well, the emergency order said COVID, we can't have jury trials. It wasn't enough for that court. Now, granted, it is going before the Court of Criminal Appeals, and I did try to see what's going on with that, and I believe they're still waiting on the state's brief. So we don't know what's going to happen in the long run, but we would like the court to see kind of where some of the other courts have led with this, or what they felt when it came to these arguments and what they ruled on. And they did rule in favor of the defendant in that case, Your Honor. So we'd have to wait to see what the Court of Criminal Appeals does, but we would argue the same way they did in Sheffield, Your Honor, that it's not enough. It's not justifiable, because we can take it one further step here to where the state can't even argue that they are ready for trial without having all the proper discovery being turned over to the state. So we'd argue that this is on the state. This has been an undue delay based on them, and that the proper remedy in this situation is not setting it for a jury trial, Your Honor. It would be for a dismissal, or like I argued at the last hearing, Your Honor, that in the alternative, if the court is not of the opinion that it should be dismissed, then that evidence should be excluded from the state being able to use it, and that we get a jury trial setting as fast as possible, Your Honor.
Okay. Mr. King?
Your Honor, I think my interpretation of what defense attorney is trying to argue is that this court should be the jury to determine whether the evidence is sufficient or not to toss out the information as is right now with the motion for speedy trial, right? The motion for speedy trial calls for a dismissal if we have violated the time limits. As we've heard, the case was filed in August of 2021. We are well within the time limits on this information. And then he turns to the motion to compel evidence and discovery. But that goes to sufficiency of the evidence. And if we were to turn it over late or in not a timely fashion, then yes, it should be suppressed, right? At that point, but we are not there yet, right? Him asking, or the defense asking for the whole case to be tossed out, dismissed outright, for lack of evidence is asking, again, the court to play jury and say, state, you do not have sufficient evidence to proceed on this case. And we do. It's the sufficiency of evidence question that he is complaining about. And he does go into the lack for the blood discovery and whatnot. But again, that would be an issue getting towards trial. And as today, we don't have any date set for a jury trial. And we would ask that one be set.
Okay. Anything further?
Nothing from the defense, Your Honor.
Okay, Mr. King, that's it?
Nothing further, Your Honor.
Okay. All right. I would like to look at that case law, Mr. Ramos. So if you'll provide that to Aleda. And if you find some case law you want me to read also, Mr. King, please let me know and we'll get a copy to Mr. Ramos also, right? So I guess I do have some questions that I'd like to have clarified. So Mr. Ramos is waiting on the blood results, right? Is that what I'm hearing?
The blood discovery, Your Honor.
Okay, and are those ready?
Not yet, Your Honor. They
Okay.
have been sent off to Austin.
No, I mean the results, are they ready?
No, Your Honor.
Okay,
Because we
Your
just got
Honor,
the
Trina Sanchez for the state as well. I can answer that question a little bit more direct if you would like.
any objection, Mr. Ramos?
No objection, Your Honor.
Okay, go ahead, Ms. Sanchez.
Yes, Judge. So the case in particular was filed in November of 2021. So while the arrest was in August, we didn't file the case until November, which is when we received the actual blood results from the lab, which was then uploaded into discovery for defense counsel. Now, the discovery request for the blood discovery that is sent out to the lab that was signed by the court in December was sent out to Austin, the Texas DPS over in Austin, the crime lab, and it's the order that you signed that the state sent out the last time we were here in front of Judge Angelini. So the discovery request has been given to the correct agency. The state, though, does have to wait for that agency to respond to that particular signed order to give that discovery to defense. That comes straight from Austin. It doesn't come from us. So it's not discovery that we give to defense counsel and say, Mr. Ramos, here you go. This is something that he's called and he comes and picks it up at the 4th floor window as soon as it's received from Austin directly. So that has been sent off, and it has been a little less than a month since that request has been sent.
All right, so Mr. King, you felt that even if you didn't have the lab results, that you'd be willing to go to trial without them?
Right, Your Honor. That is the question of sufficiency of the evidence. That is the state has the burden to prove their case, right? So if we go to trial and we don't have the blood results, we don't have a lot of the other stuff the defense is complaining about, we're going to lose. The jury is going to say, okay, you've not proved your state case, we're dismissing. So that's why I'm arguing that he's asking the court to try the facts of the case. And I think the facts of the case should go to the jury. And again, sufficiency of the evidence question, if he's complaining that we're beyond our time, again, a motion to suppress on that basis is different than a motion for speedy trial.
So basically you're saying that, yeah, you could not prove your case without those lab results, right?
No, I'm not saying that at all, Your Honor. There are times in which we have to prove a case without breath or whatnot because there might be some kind of issue, which we can use the videos of the stop and other things to show that he was intoxicated, right? So it's a collection of the evidence that we present to the jury to say, hey, look, he was driving under the influence or while intoxicated. under Texas law, and you can see all this. And of course, the defense can poke holes and say, yeah, you didn't see the blood, did you? You didn't see the results. You expected to see a BAC, but you didn't have it. That's where the argument comes in from both sides. And that's why I said it really is a question of fact. And the blood results and things like that he's arguing for is of a factual issue. Again, why I said it's more of a suppression issue for not providing the results, perhaps. But I don't think it calls for an outright dismissal of the information or complaint in this case due to what they perceive as an insufficient amount of evidence from the state.
Right. But I mean, you just agreed, I suppose, that it would be very difficult to find him guilty without those blood results, right?
Perhaps. I think it would be a lot more difficult. I will concede that it would be more difficult without it, right? But it's not
burden to prove beyond a reasonable doubt, isn't it? I mean, it really is.
Right, but it's not impossible, and that is a question for the jury to decide.
That's true. Okay. All right. So what it's all about is the state has, I mean, people that provide those results are considered agents of the state. So when they don't do things in a timely way, it actually hurts the state, right?
Well, of course.
Right. I mean, and you have no control over that.
Right.
But at the same time, it's been 7 months, 8 months, something like that, right? Roughly since August. No, and so on a motion for dismissal due to lack of speedy trial, the trigger is the arrest date. It's not the date the information is filed.
And that was August of 2021, Your Honor.
Right. So we're now in March. All right. Was let me see, I wrote it down. August 29, 2021?
That is correct. August 29th of 2021.
Well, it's this whole thing is just an evaluation because basically what the defense is alleging is that you all were somewhat, and this is not you because basically it's your agents, it's the labs.
Correct.
So, but I mean, that's why I say it's not personal. You weren't even here when this case was filed, I don't think. Were you?
No, I was
Maybe
not.
you were. Okay.
Started in December.
I don't think Ms. Sanchez was here either. So it's not personal. It's not like something you failed to do. But, that motion to dismiss for lack of speedy trial is it's just like motions to suppress. Those are pretty important tools, I guess.
They are, Your Honor. But even with the timing, and this is argumentative, I'm not saying the state would do this. We're still within the 2 years of filing. So even tossing out the information means we could turn around and refile. Right. So that's where it's kind of like, even tossing on the ground, I don't know. I've done it before in another case. And that's exactly what the state did to me as a defense attorney.
Right. Well, is there anything more that you want to add, Mr. Ramos?
No, Your Honor, other than, I understand the state's position, and I think the court is absolutely correct. This is not a personal attack on Ms. Sanchez or Mr. King. I know that they cannot control DPS, but the fact remains that, this is not about, asking the court. I've never once argued any of the facts of this case or the elements to the court. I've never asked the court to make a sufficiency determination in regards to this case. This comes down to constitutional protections, Your Honor. And really what it is the right to a speedy trial. And that, based on what the state's agents have done, has been violated. Your Honor. I think that's clear, and there's really no remedy. You know, if we were to play chess and think about the moves that are come forward from the court, no matter what we do, there's no remedy that's sufficient enough to protect his constitutional right to a speedy trial, other than to dismiss, or, like we said in the alternative, to exclude that evidence from being used for not being turned over in a timely manner, and then setting this case for an immediate jury trial as soon as possible, Your Honor.
Well, I mean, that could be something that would be basically, no, but no, I think that I think we all have to take our constitutional protections very seriously, and that's not defense or prosecution. It's, you know, as citizens of this country. So I don't know what I'm going to decide, but I'm going to evaluate very carefully. And there's case law that gives you almost a step-by-step way to determine. I mean, it's pretty clear. So at this point, I don't know what I'm going to do. I want to read the case law. I want to really think about it hard and seriously, because it is an important issue. It's very important. I'm not even giving you a clue because I have no idea what I'm going to do. Okay.
Yes, sir.
If you all find case law that benefits you, Mr. King, I'm certainly glad to read it and take it anytime. And if you find more persuasive case law, Mr. Ramos, please just send it to me. I think it's very important that we do our best to, make sure that, well, it's all about justice and truth, right? Really. Okay. We're going to adjourn this hearing. If you all think of anything else, I'll be glad. I'm still open to more persuasion, okay?
Thank you, Your Honor.
I can't tell you how long it's going to take me to do this. I'm going to try to do it as fast as I can. Mr. King and Ms. Sanchez have been working very diligently, very, very efficiently. I've just been very blessed with wonderful prosecutors. Well, they're not mine, but it makes my life a lot easier when they take this work very seriously. And so it's an advantage to have people that are very committed to getting things done. And that's why I can see how they might feel that, it's not fair because it's only been 7 or 8 months, and that's typically the what normally can trigger this, right? So I'm going to make a decision and not consider any of the parties. I'm just going to make it on the facts and the case law that I read. So thank you all very much. I really appreciate everybody's, you all made good presentations on both sides.
Before we close this hearing, Your Honor, we would at least like to have another hearing set, just so we don't lose the case or as we're waiting for your decision.
Yeah, we'll reset this. I guess we'll reset it to, let me see, what's the trial date? I'm looking at the wrong one. Here it is. It looks like May 2nd.
For jury trial? Okay.
We'll set it for trial May 2nd.
Okay.
And Your Honor, before we hop off the record, when is the deadline that you would like any additional submissions on this matter, whether that be case law or whatnot, to be sent to you and defense counsel from the state?
I think that I'm going to, considering everything that's going on, or catching up, when I would think 2 weeks from today.
Okay, Your Honor, thank you. And anything that is submitted to the court, we will also CC defense and any correspondence that we have.
Yes, I think that's a great idea. I mean, I think that I know I can count on Mr. Ramos to also share anything else he finds. So we all just want to get the right ruling, right? So, okay. Thank you very much. Appreciate it. And this hearing is adjourned. I hope that 2 weeks from now, let me see, what is that? I never have my calendar handy when I need it. Here, hold on. I got a calendar here. So what do y'all think of this? All right, we are in March and today is the 16th. So, okay, by 30th of March, I'll try to have something. I'll write it down so I can put it in my calendar. Ruling due 30 March. And I will take any submission up to that time, okay?
Yes, Your Honor.
So ruling due March 30. Okay, thank you all very much. You all have a good afternoon.
Thank you, Your Honor. May we be excused, Your Honor?
Yes, sir. Thank you very much. You all take care.
You too.
Chat message, Judge.
Okay. Aleda, do we have anything else? Mr.
Well,
Bunk
I
is,
have there Charles Bunk, attorney,
okay.
and they were gonna approach to you, I guess one of his assistants, but
All
they're
right.
not there. And then you have, I
I'm
think-
here.
Natasha, okay.
Okay.
Hi, Judge.
Can you turn on your video, please?
Yes, yes. Let me put it on right now. Sorry.
Okay.
Hi.
Hi, how are you doing? Uh-oh, something happened. You got muted. I don't know if I did that. There we
Okay.
go.
I think I'm good now. Yes. So we were just hired on a new case 2 days ago. We just got the bond set for the felony out of the 379th yesterday. However, we still need a bond set for this case that she hired us on. I believe it was an at-large case, so she was never magged on it. But we wanted to do like a satellite bond tomorrow with her.
All right. And so what is her name?
Her name is Danielle Rodriguez.
Danielle Rodriguez. Okay, do you have a cause number for that?
Yes, 677-568.
Okay. And what is the charge she has?
It is a Berg of coin op machine.
Oh, okay. Okay, and all right, so she's not here today, but you're going to bring her in tomorrow to mag her?
Yes, ma'am.
So I'm thinking tomorrow, we'll have our plea docket at 1:30. Probably about 2:30, we can, oh, is that too late to get her through mag, through satellite?
Yeah, I think they have a cutoff at 3. Yeah.
So I guess we can do that at 1:30, make it number 1.
Okay.
Because it's just a matter, so are you just going to do like a regular surety bond on that?
Yeah, we're going to post her bonds for her.
Okay, so you just need to know what the bond would be.
Correct. Yes.
Okay. I would guess. I think, Ms. Sanchez, do you have any opinion about a proper bond for this kind of case?
Judge, I don't even know what the case number is. If given that information, I'd be able to talk to you about it tomorrow afternoon.
Okay. Well, I guess we can wait till tomorrow at 1:30, right, Miss Natasha?
Sure. Through Zoom, and would Miss Rodriguez need to appear as well?
Yeah, if you're, well, you can actually come to the courthouse and that way you can get the paperwork much more easily that way. Through Zoom, it gets a little convoluted. And so what they will do, they will prepare paperwork. They'll send it to me so I can sign through Adobe Sign. And then they'll get that signed paperwork and then you can proceed for that. Okay.
Great.
But,
Your Honor, I can also take a look at this afternoon as well, and then send an email maybe to you and defense to pass any additional time. So I just need to take a look at it is all.
okay, the cause number is 677568.
Thank you, Judge. I'll take a little bit of time this afternoon and review that, and then I can reach out to the court.
Okay, thank you very much, Ms. Lynches. Okay, then we'll see you tomorrow, Natasha. What is your last name?
Benavides.
Benavides. It's nice to meet you.
Thank you. Nice to meet you too.
So we'll see you tomorrow at 1 o'clock, okay?
Okay. Thank you, Judge.
Thank you.
All right. Bye-bye.
Bye. All right. All right. Does it seem like we are done, Alita?
It seems like it, at least the court wise, but you're not.
All right. Well, thank you all very much, Mr. King, Ms. Sanchez, Mr. Richardson, Ms. Benavides, and Deputy Butler. You all have a great afternoon. Thank you.
Judge, you too.
Thank you,
Bye-bye.
Judge, as well.
Oh, Aleda, do you just want to email me if Mr. Ruiz gets back in contact?
Yeah, I'm still waiting on Mr. Garcia to respond to see what happened, and then I'm gonna give them your email address so they can contact you right away.
Okay, perfect. Thank you so much. Yeah, I think he just left after the plea. He didn't go.
Yeah, I know.
Oh, did I not tell him to go to the breakout room? Maybe I forgot.
No, he just left, Judge. I think I jinxed us when I said the whole communication issue earlier.
Are we off YouTube?
We'll track him down though.
Okay, sorry about that.
No, you're fine. Judge.
And Judge, Aleda already has the paperwork emailed to her for the Rodriguez case, the mag order and the commitment. She
Oh,
just
good.
has to send it to you to sign. So we're ahead of the game already, maybe a little bit.
Okay, see why you cannot take off, Deputy Butler? You are stuck in this court. Thank you. All right, so we're ahead of the game. Good.
Your weddings are here.
Well, then let me see what Alita needs. Deputy Butler, have a great afternoon. Thank you for all your hard work. It's very much appreciated.
I want to hang around for a little bit more because you have a couple of weddings here, right?
Yeah, I'm coming over in a minute.
Yeah,
Are they
they're-
already there?
They're in the hallway already. Yes, ma'am.
Oh, I thought it was at 3:30. Okay. I'll be over in just a minute. Let me see what Alita wants.
They got to wait on you, so they're going to be here.
Your Honor.
Well, marriage is a life sentence, so.
Right? It's the title to someone else's name, and it's like, oh my gosh. Like buying a used car.
Okay.
I'm going to get out of this one.
Have a good afternoon.